One other term, or sort of meta-term, is implied in all contracts. The duty of good faith is both an implied term and a way to understand every express term. And the duty of good faith pervades our understanding of contracts, because once parties are in a contractual relationship, they owe certain duties to each other. Maybe not fiduciary duties, maybe not a duty of swearing of fealty, but certainly duties to each other because these parties are now in a new relationship. And so what are those duties? Well, they're discussed in a vague, broad, but flexible way as duties of good faith and fair dealing, sometimes referred to as commercially reasonable dealing. So what is this duty of good faith and fair dealing? Well, it's never really stated in super clear terms, in part because its value is being a flexible doctrine. But Restatement Section 205 and UCC 1304 and 1201-20 remind us that they are persistent in all contracts, both for sales and not governed by the UCC. The historic case of Lucy Lady Duff-Gordon illustrates an early development in this modern doctrine. Here, the judge found the contract parties must have some duty to bring profits into existence. They had agreed to share profits, so there must be some duty to bring these profits into existence. Otherwise, the contract would make no sense. And we see here in an early stage, the duty of good faith can help us prevent contracts from being illusory, can make contracts real because there is a duty of good faith in performance. Judge Posner discussed other terms implied in good faith in Market Street Associates. Once in a contractual relationship, parties have a duty of good faith and fair dealing toward each other. Although this is less than a duty of, let's say, full candor, contract parties cannot take deliberate advantage of an oversight by their counterparty. Special terms regarding good faith for the sales of goods subject to output and requirements contracts under the UCC do apply. In output contracts, you purchase as much as someone can produce. And in requirements contracts, you purchase as much as you need. This creates a little bit of room for mischief, because on the one hand, if it's not profitable to produce, maybe you could simply stop production, you produce nothing, okay, your output zero. On the other hand, maybe the price has gone down, you can resell something on a secondary market, and so you purchase much more than your requirements in order to make an additional profit. Well, both of those cases are problematic and prohibited by the duty of good faith. We looked at one case, the Crushed Toast Corporation, where the plaintiff agreed to sell, defendant agreed to sell rather, and plaintiff to purchase all the breadcrumbs made at this factory. It became unprofitable to sell breadcrumbs at that price, and so they shut down production completely. This was found to be a breach of good faith and fair dealing. Likewise, defendant agreed to sell and plaintiff agreed to buy all of their fuel oil needs for a low price per barrel. When the price of fuel oil went up, the buyer nearly doubled their order in order to either stockpile or resell the fuel at a profit. This likewise was a breach of the duty of good faith for the sale of goods. Returning to contracts in general, meaning this could apply to services as well, contracts often have termination rights. And we saw this in the case of Castar Builders. Parties may have rights to cancel a contract for any reason, but even the ability to cancel a contract for any reason is not so broad as it might seem, because the ability to cancel for truly any reason would make a contract illusory. Instead, these termination rights are cabined in by the duty of good faith. So canceling, even for any reason, must be within the bounds of operating in good faith. In Bacalome versus Alcoa, we saw something similar, where the court said that one party may not destroy or usurp the other party's fruits of the contract. That is, so long as the parties are bound to perform as contract parties, one cannot take deliberate advantage of an oversight by the other. The duty of good faith precludes that.